Hey, you're still here. I can't believe you've not escaped this room yet.
We're doing really well. There's a bit of jet lag, a little bit of dehydration, a lot of coffee. Oh, and that bubble tea, 43 grams of sugar in my drink at lunchtime.
How on earth did you manage to drink? So the straw was standing vertically in the can. It wasn't moving or wavering or anything. It must have been.
The sugar had dissolved the paper and to the metal at the bottom is basically what had happened. There 43 grams of sugar.
You do find some interesting places to eat, don't you?
That was nice. That was a Korean. Yeah,
I don't think you found that one there, to be fair.
No, it was there.
But you've got a favourite eatery, haven't you?
Oh, so our diner, Metro Diner, little plug. When I got here on Saturday night, my taxi driver, Adam, we made friends, Adam, said that's where you need to go and eat. So I went, and there was rap karaoke downstairs, full of people coming out of the country and western concert.
Are you sure you didn't mishear what kind of karaoke?
No, you couldn't mishear it. It was very close. But there's loads of people in cowboy hats and boots. There's a rap karaoke bar, and then the diner upstairs.
But no, they wouldn't have guns because there was a sign on the door saying "Do not bring your guns in."
And their pants went around their knees because it said "Keep your pants around your waist."
You've been eating kind of quite interesting food. The only way I could describe it is not food.
Oh, really? It didn't look a lot like that. One thing I had the egg white scrambled egg or something, and then fried beet. It was basically a hamburger in breadcrumbs. Cream on, and then grits.
Oh, yeah.
And it was just the beigest meal. It was like a colour palette. It's like in Star Wars, the colour palette for the Jedis in Tatooine. It's like sand and,
I don't do Star Wars.
It was actually quite tasty. And grits, nobody knows what grits are. I've discovered.
Not even the people who sell it to you.
I've been told. One person said sweet corn. Someone said polenta. Basically at the same time. Nobody knows what it's made of. It was nice though.
And the first time we went to that diner, you had some strange thing. So it was biscuits, but it was more like a sponge cake.
Yeah.
In gravy, which was some kind of
Campbell's cream of chicken soup.
Custard or
something.
something.
Yeah, it was pretty odd.
Chicken custard or something like that, yeah.
It wasn't biscuits. Biscuits and gravy in Britain would be what, hobnobs and bisto.
Hobnobs, yeah.
It wasn't that. It's good though. And I've had catfish as well. That was actually really nice. It's quite juicy.
Lee Davis and Gwilym Roberts are the two IPs in a pod, and you are listening to a podcast on intellectual property, brought to you by the Chartered Institute of Patent Attorneys.
Should we get the guests on? We are exhausting our friendly banter.
I'm not even anymore. Yeah.
So I know these won't go out in the kind of the order we recording and stuff like that, but we're sort of like halfway through one day, aren't we? And already I'm almost sick of the sight of you.
Almost. You're doing well then.
Yeah. I went on a divorce at some point after this. Hello both, how are you?
Great, thanks.
Can you introduce yourselves? Would you do that for us?
Sure. My name is Paula Clancy, and I'm serving as president of the Intellectual Property Institute of Canada. I'm going to let Kat introduce herself. I'm a trademark lawyer and trademark agent, and very happy to be here with you both.
Oh, you're really welcome. And of course, we've met in the UK recently as well.
That's right. So, yeah. And we're going to meet again.
We are. Yeah.
Why?
Because we are entertaining our Canadian friends when they come over in just a few weeks' time.
Yeah, so friendly. Sorry to interrupt.
No, not at all. My name's Kat Lovrics, and I am also on the board of the Intellectual Property Institute of Canada, or IPIC. I, too, am a trademark lawyer. I also practice in the area of copyrights.
Fantastic. Well, it's lovely to have you on. We have a really talk about special relationships when you're in the States, don't you? But we have a really special relationship with our Canadian friends. And it's fantastic that you're with us. So let's start with the relationship, because I just wanted to say a little thank you. We've written to you and thanked you. I speak with Adam, your chief exec, fairly frequently, and I've thanked him. But I just wanted to kind of publicly thank you for the work that you did with us around the UK joining the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, the CPTPP.
We're always happy to collaborate. And I want to thank you, actually, because you've been wonderful in terms of supporting our aim to clarify the scope of agent privilege in Canada, and CIPA's support has been tremendous. So we wanted to thank you back.
So we can explore some of that throughout the podcast. But the reason why the CPTPP thing was so important for us was the UK announced that it wanted to join this Trans-Pacific trade agreement. We spotted fairly early on that the IP provisions in that, particularly the requirement for the UK to introduce a grace period, were potentially
incompatible,
inconsistent with
reality,
with the European Patent Convention. And of course, the UK enjoys a place of esteem and importance in the European patent system, and we just wanted to make sure that there was no we didn't want the conflict to ever materialise.
Right.
So we were fairly happy that if we had to have that legal argument at some point down the line, we might win it. But actually, the injury would have been done by some of our competitors in Europe saying, why would you use the UK for this work anymore if their future place is at risk? And we just didn't want to get in that sort of competitive sort of state where that was being used against us as a marketing ploy. And so we came to IPIC early in that, and you had conversations with your government, you wrote letters of support. So it's thank you.
Yeah, and I think your relationship with our CEO Adam Kingsley has been very good in since you've both been, with your respective organizations, which helps because it keeps the dialogue going.
Yeah.
It keeps us aware of the issues in our respective jurisdictions. And there is a lot of commonality, and harmonization discussion that we can have. So it's been terrific to have that closeness of the relationship between the two CEOs.
I think one of the reasons why Adam and I are so close is because we both came to the world of IP from entirely different world.
If you were about to say he was a plumber.
He wasn't a plumber.
Okay. I thought you were going to say you both like Scotch, but we'll
There's that as well. We do generally like a drink. We probably shouldn't get this into an alcoholic podcast, should we? But
no.
But no, we do. Yeah, we just get on well.
No, it's been a great relationship and great partnership.
So where should we start then? Should we start with? Can we start with regulations? Because one of the first things I did in that relationship, I know for some time IPIC were campaigning, lobbying, asking for the profession in Canada to be regulated.
Right.
And I remember I came over to a board meeting in Montreal, probably maybe 7 or 8 years ago, to speak to the IPIC board as it was then about our experience. Very different experience back in those days of having set up a regulatory body. And that I've been recently virtually to a board meeting to talk it. You got what you wanted. You got a regulated profession. How does it feel now?
Well, okay. Let me walk you through how that came about. So, IPIC and the profession has indeed been lobbying for about 20, 30 years to have self-regulation.
Yeah.
That's what we wanted. What we got was independent regulation, which is, not the same. It's a different model.
Yeah.
We're okay with that now. We understand that that's kind of the way, the shape and form that professional regulation is going. But of course, this was very new to Canada, and the setup of the college, unfunded, they did not receive any government funds to set it up. Meant that it was a hard transition. And last year we did run into some issues because the fees went up dramatically for licensees. And also there were many changes on bylaw changes that were made without any consultation with the profession, which ruffled some feathers. I think that can be explained by just the newness of it all. And it's just a new model. And we've made at IPIC real a concerted effort to try to work with the regulator to ensure that the form of regulation is more modern and at a minimum consultative, that the profession feels like they have a say. And I think we've made some progress on that front.
Oh, cool. That's good to hear.
Yeah. We definitely have. I think we're on the right track. And we're very happy to have, finally a regulator in Canada and elevate the profession to the level it needs to be for patent and trademark agents.
So the law is different. So in the UK, CIPA is the approved regulator. We are named in law as the regulator, and then the law then tells us that we can't do that. We have to do that by creating or contracting out regulation to an independent body. So we've got that independent thing, but in a different way.
In a different way, yeah.
So it's meant that we've had to get used to being a representative professional body. So the work we do for and on behalf of our members has become really, really important. But we can't lose sight of the fact that we're regulated. So we've had to develop a relationship with our regulator. I think the thing that I can tell you, the thing that I said when I came to the board meeting is it takes a long time to get those relationships right. So you're early doors in that, aren't you?
And for us, it was really comforting to hear from you, Lee, on kind of the history and the progression of the regulatory model in the UK, because we realize we're in early days and we realize that, that there were some growing pains, but ultimately it's a good model, and we needed it, and we welcome professional regulation for sure. we're going to talk about agent privilege, hopefully, later on in the podcast. But, one of the things, so originally we had asked for, a self-regulation, and the two key issues that the profession had in mind was, getting agent privilege, full scope of agent privilege, and also, having some protections against unauthorized practice.
Yeah.
The scope of agent privilege, I'll give you a little. You want me to do it? Okay, sorry, Kat.
Let's go where it feels right.
Let's do it. So we finally were able to get statutory privilege for patent and trademark agents in 2016. Somewhere around there. And for about 5 years, we operated under the assumption that it was like solicitor-client privilege. It was the full scope of agent privilege for patent and trademark agents. In 2021, there was a decision in Canada where a prothonotary reviewed claims of overprivilege and determined that the statutory scope of agent privilege was far narrower than solicitor-client privilege. In fact, it was so narrow that it only related to discussions about an invention, the inventor's invention, and prosecution with the patent office.
Right.
So anything to do with validity, infringement, freedom to operate outside the scope.
Which completely removes the point of having privilege at all.
Right. And our college now has competencies, and those, infringement, validity, those are part of the competencies that patent agents need. Core competencies, right? So on the one hand, we're requiring these competencies, but then we're not protecting discussions, where patent agents are competent to have these discussions. So that created some angst. So that's one thing we're trying to address. And then the second thing was unauthorized practice. In early days, the college had indicated that, part of it is resources. They had limited resources, but that they weren't going to be looking at unauthorized practice. That's changed too.
Oh, okay.
So, that's made the profession a little bit more comfortable now because they seem to be willing to hear about unauthorized, or at least receive complaints about
unauthorized practice in the sense of someone
who's not
qualified to do so, not registered,
putting themselves out to be right. So originally the SAPATA, which is the College of Patent and Trademark Agents, had said really their primary focus was discipline of licensees. Yeah. But that's not what we had bargained for. We wanted it to be, regulating people who were not registered.
You're the good guys, right?
Yes, exactly. There's so much training that goes, difficult exams, difficult pass rates. And so people, if they put themselves out there as patent and trademark agents when they're not, that creates a problem, right? So, and now we've seen the SAPATA more willing to
So how are they going to do that? So let me first of all explain how it works in the UK.
Yes.
So we have protection of title, and that's written in legislation. So the 1988 CDPA, Copyright Design and Patents Act, gives CIPA the ownership of title, and we've passed it on to our regulatory body, separate from the regulation of the profession. So if someone is putting themselves out they can't even use the term patent attorney. So it's about whether you're registered or not. You can't legally use the term. So that's written in law, so we can use that. But actually, we're also in a position where representation at the UK Intellectual Property Office isn't regulated. So anyone can act before the Patent Office. Doesn't matter what they call themselves.
Interesting.
So it's interesting to see what your model might look like, because we're in that sort of halfway house where the title is protected, but actually doesn't stop you in any case from.
Interesting. That's new. That's a different way to approach it. Yeah. No. In Canada, you do have to be registered in order to be able to interact with the office. Yeah. So I guess there's some protection there. But what we're seeing is that people. Some unauthorized practice. The way it works is that they'll put themselves out as being able to help people on patents and trademarks, and then unbeknownst to the applicant, they're preparing the application as if at least on the trademark side, can't speak to the patent side, but as if the applicant was a self-filer. But meanwhile, the applicant has no idea that they're considered a self-filer because they've been dealing with a so-called professional. And so, it leads to problems like that. So that's the realm that we're in right now. I don't know if you want to add anything, Kat. I've been doing all the talking, so
not at all. I think you hit the nail on the head.
Okay, great. Okay.
And presumably without necessarily the protections of things like insurance.
Correct. And that's another big, concern. And also, the tarnishment of the reputation of the profession as a whole when you have bad things happen.
Yeah.
You know what I mean? It's
the public don't necessarily distinguish between.
It's full on. It's basically consumer protection as well.
It is consumer protection,
And I think that is Zapata's vision, is that it's about protecting the public interest.
Right.
And I think that that's underscored some of the growing pains that we've experienced, is seeing that as the driving mandate for the regulator. But I do think they're moving. I'm hopeful that they will begin to regulate those that are holding themselves out falsely. And in an innovation economy where IP is incredibly central to the future, I think it's increasingly important that we protect that and we ensure that there are competencies for those that are delivering.
And I think we've been able to communicate the fact that the profession also wants, the public interest, has the public interest in mind. We are also concerned that, Canadian companies get the best strategic advice, get, proper protection for their innovation and for their trademark. So I think we're finding that there is a lot of alignment between the regulator and the profession, and that's just through discussion, working hard at the relationship, and getting past these growing pains.
And I know you've done a huge amount of work, haven't you, with raising public awareness of the importance of IP. Was it the Own It campaign?
Own It campaign, yes. Yeah, we've done a lot of work at IPIC on
I've got
that.
a T-shirt at home still.
Oh, good. There you go.
Visit. You had a good time, I'm sure. Wow.
Yes, it was great little hashtag Own It T-shirts. Really, really good. Visually, really impactful.
Yeah, great videos.
Yeah, I remember the launch of the videos at
the videos are
conference.
great. Yeah, for sure.
That's interesting. So going back to the privilege thing as well, the 1988 UK Act, I think, was where it came in basically for us as well. So that was just before my time. So, I came into a world where it was a given. It kind of just happened. Mm-hmm. It's difficult to imagine a world where you'd have to think how to express your advice or do it in a phone call or something crazy like that because of the lack of protection. It's impossible to, you can't advise, can you?
Well, and it's meant duplication of costs for clients ultimately, right? Because you have to bring in a lawyer to protect the conversation.
Just to protect the conversation. Yeah, wow.
Yeah.
Well, and it's strange because both of us are lawyers and agents, and so we have the benefit of any discussion.
You can take for granted privilege.
Exactly, but we would hope that we see a movement on this front such that agents that aren't also lawyers get that shelter, get the cover.
So would this require a further law change or some kind of clarification of the law?
What we would like is statutory clarity on the full scope of agent privilege. So that's what we're, as an association, we're lobbying for, is to clarify the scope of agent privilege. If we can't get statutory clarity, at a minimum, have the minister say, no, this was always the intention.
Yeah, the intent. Yeah,
right. So that there's there's some guidance to the courts down the line in cases. But, the reality is if we leave this to the courts, it's going to take years to resolve. So we need to have that answer faster because, as Kat pointed out, for an innovation economy, you need to be able to have fulsome discussions with your patent agent, with your trademark agent, and right now that's in question, and it means duplication of costs.
And in the spirit of the public interest, that it's not us that benefit; it is ultimately the client that needs the cloak of privilege.
Exactly. So sit there miming you're invalid. You can't be doing that. That did not work on the podcast.
Miming doesn't work on the podcast.
No. But it sounds like you thought you had statutory clarity, and then it got.
Yeah, it was.
What happened? Was there an opinion?
It was a case. It was a Jansen versus Sandoz case, and this was a decision by a prothonotary, and it really limited it interpreted privilege very narrowly, the statutory privilege, even though the wording is broad and vague. The interpretation that was put on it was very narrow, and so that it just it has called into question the full scope. So now people are proceeding with extreme caution in law firms just to make sure that there's no issue.
Of course,
but hence the duplication of costs, of efforts, and at the end of the day, we have a college now for patent and trademark agents that has set the competencies, tests on the competencies, which include invalidity, infringement opinions and all that sort of thing. So, to exclude those conversations from being cloaked with privilege is counterintuitive, given that we have a regulatory body.
Is your sense that there is an appetite to address this, or are you finding the door is opening?
Yeah, well, and this is where SEPA support is really helpful for us. So, initially I would say there wasn't much appetite. The idea was let the courts resolve this issue. Let the judiciary resolve it. But we've been very fortunate that a couple of members of Parliament who are very astute and understand Canada's innovation economy, understand the importance of having this, have kind of championed the cause. And then, between that and some senators that are supportive, but also having outside organizations like yours say, this is an issue that is important, not just to Canadian innovators, but also to foreign companies that are potentially protecting their IP rights in Canada, is very helpful. And so that thank you.
Exactly.
But what it does for me is it reinforces the intrinsic value of a professional body and membership of that professional body, because these are the things that we should do for and on behalf of our members. For us, it was the CPTPP thing, but there's always been stuff that we've needed to do. For you, it was the kind of lobbying around the creation of a regulatory body, and now this is always something you can do for members. Because one of the reasons Gwilym was really keen to be doing podcasts with other professional membership associations is because he wants SEPA to be as good as everybody else, don't you? And we're learning from this.
It's about time you pull your socks up, Davis. and your pants. You saw the sign in the diner. It's interesting. I think SEPA does a good job. And
it does a fantastic job, I'll tell you that much. It really does.
Big Lee up. I don't like doing this, but I have to. And I think when you have that representation at so many levels, and the cohesion as well, you get everyone working with one voice, that's really important too. But it's interesting. It sounds like it's a battle for status almost. For we deserve full privilege rights. We ought to be regulated because we're good enough to merit it.
Right.
So, but I'm quite surprised that wasn't something that was in place in the Canadian profession before, because you're very highly reputable, well-regarded, and a well-established profession. So why wasn't it there before?
I think that it can be perhaps historically traced to kind of, the legal profession wanting to keep a rein in on who it gets, privilege. Accountants at one point were saying, hey, all of our communication should be privileged with our clients too. And so a lot of the objection to expanding, privilege to other professions has been, some lawyers want to keep it kind of close. Interestingly, it tends not to be IP lawyers. IP lawyers have advocated very strongly for many years for the full scope of agent privilege for non-lawyer agents. But it's lawyers in other areas of law that
it's ever thus
that like to keep the
we call it collateral damage.
That's right. So I don't know if that's kind of your sense too, Ken.
I agree. I think it's preserving a sanctity in the legal community, and I completely agree that IP lawyers, I think, are uniformly supportive of privilege.
I've got
being
your
accepted.
next T-shirt. Right, you got to own it was the one you got so far. The next one, privilege is not a privilege.
There we go.
Come on.
It's not quite as snappy as own it, but it is the Ronseal approach, isn't it? Other paint brands are available. It does what it says on the tin.
Yeah. But I think going back to Kat's comment, it's not the lawyer's privilege. It's not the agent's privilege. It's the client's privilege, right? Yeah. So that is the key takeaway here. It is to protect clients, and so that they can have...
It's not our privilege. It's your privilege.
Oh, there we go.
And to your point about, miming to clients may not be miming to you. And the things that they disclose to you should be privileged by virtue of the expectations that they have with respect to advisors in the IP field.
Right.
You've got the strongest argument, haven't you? How can you not listen to that and come out with a sensible position?
No, completely. It's just,
and it's a long-standing profession. I mean, IPIC is about to celebrate its 100th year anniversary.
When's that?
This is in 2026.
Okay, we
need to go to podcast.
We always do a fairly similar kind of presentational thing for our overseas sister organisations, sibling organisations.
Oh, you're going to give them the SEPA ceremonial pie?
Yes. I've got to start baking it now.
100 years,
I love it.
Pie.
I'll remember that.
Please do.
I'll remember that.
That's not true about the pie, you know that.
Yeah. As long as it's food and not food, right?
There we go.
Full circle back to your palate food. But so it's a profession that's been around for decades, and so in a highly competent profession, and the exams are very difficult, highly qualified people, very difficult to actually pass the exams, and that's something that they're trying to change. So all the more reason to elevate the status of the profession by having.
And that statement you made earlier on about needing or wanting or seeking regulation. Having seen regulation, I think, gosh, fancy going looking.
I know.
But again, it shows,
but it's about that narrative of public trust, isn't it?
Exactly.
That's what it's about.
It's credibility.
Yeah. And that's why I think unauthorized practice was such a big topic for the profession, because it weakens public trust when you come up, with stories come out of disasters. And we've had a couple in the province of Quebec, where, some Canadian companies were badly defrauded because they were dealing with someone who was not competent. And so it's a huge concern. Yeah.
Yeah. I would say the thing that you always hear from senior civil servants in the UK when you ever go for regulatory training is show me the bodies. Show me the damage.
Show me the damage. Yeah.
Should we move? We spent a lot of time on privilege.
I'm sorry. Yeah.
No. It was really important to do so.
It's the hot topic. So we've covered two points. There.
And as I say, we always say these podcasts are for you as much as they are for us. So you can use this to show your members what you're doing. I'm sure they know. I'm sure they know already. But so I was taking a little look at the strategic plan. And it says all the kinds of things that we say in ours, Gwilym. You probably know our strategic plan off the top of your head.
I can recite it now, but I think it takes too long.
So it talks about professional representation, it talks about professional development, it talks about thought leadership, and generally promoting kind of EDI and the sorts of things you expect.
World-class IP community.
Yes. So do you want to tell us a little bit about how you deliver on all these grand aspirations?
Well, first, IPIC is truly the voice of the IP profession, which calls for self-regulation, which turned into independent regulation as a reflection of. And in Canada, it is the organization that if you are an IP professional to be
in-house and private practice
uniformly, and we keep our members abreast of developments in the law. We do a ton of educational programming from experts. There's mentorship programs. We're in the midst of an IP outreach, an outreach program about careers in IP.
Getting the next generation of IP professionals.
And I think on the thought leadership side, not only do we advocate for matters that benefit our own profession or are important to our own profession, but we are also very active before the government on regulatory change when it comes to intellectual property. In 2019, we had huge.
I think you were before one of the standing committees.
Committees.
Maybe tell them a little bit about that.
On the right to repair. So we had in Canada there is a private members bill that was introduced on right to repair, and there was a tremendous amount. Usually, private members bills don't move quite so quickly, but there's a tremendous amount of government support for this particular bill, and a tremendous amount of industry concern for the bill, because the right to repair, the way that the exception to the Copyright Act was effectively framed, it would have opened up both a primary market where consumers can repair their own things, but also enabled the secondary market basically to break technological protection measures. So by way of example, the car industry was very concerned. There's a whole series of things that these technological protection measures aim to protect that are in the consumer interest.
Like brakes or something.
Exactly.
Something
Medical devices was another example. There was a number of companies within the medical device community that you shouldn't be able to tinker with your pacemaker or whatever. Exactly. And it was really a very broad-based piece of legislation that I think was in response to consumer demands. It was also in response to the Canadian agricultural community. For example, many farmers will buy very expensive farming equipment, and owing to integration of technology in the farming equipment, they weren't able to repair that equipment. But rather than taking sort of a surgical approach to address the consumer concerns, or a U.S.-based regulatory approach, which is, you identify the particular device for which the right to repair should be introduced, and then there's a whole framework, including safety, environmental, and a whole series of other concerns. It was just a
one
broad-
size fits
exactly.
all. Yeah, one size fits all.
And so I had the opportunity to represent the Intellectual Property Institute of Canada. There were many people to thank for our submissions, many involved in the background before the government. And I won't say that we changed the course of law necessarily. The bill is still moving forward, but in a somewhat altered form. What I will say is that the government, as part of its budget bill, did say that the government itself is committed to introduce a right to repair. So I think the anticipation is that we'll see some form of consultation, hopefully, from the government on what that should look like. And then hopefully we'll see regulation that gets introduced. IPIC's position, having consulted with the IP profession broadly, that represents all interests across all industries and all interests, was that a regulatory approach was best suited. That we shouldn't be opening things up. If we shouldn't have a right to repair for everything from medical devices to tractors to cell phones. There's different considerations.
How did you find the evidence session? I've done evidence sessions. How did you find it?
I'm sorry?
How did you find giving evidence?
It was a very interesting experience. You could see that there were certain perspectives that those that you were giving evidence to had. What I thought actually was really encouraging, though, was clearly we were being deferred to as the subject matter experts in this area. And the reality is that this was under the Copyright Act, which is a very nuanced piece of legislation. Yeah. And you could tell that you had the ear of government on, we hadn't really thought about all of these.
I've only attended one of those in the past, and I was amazed at how receptive and engaged the senators were that were on the committee. And so it's a fun experience and process to go through, because you really feel like you've had the ear of the Canadian government, and whether they implement your submissions or not, at least you've had a chance to be heard. Yeah. Exactly. So I think
also just through that process, you're demonstrating value to your members, aren't you?
Of course.
We have access to government. We're in there. We're doing this for you.
And hence the voice of the IP profession, which is, one of our pillars. That's what IPIC is. And we take that role very seriously. Lobbying is a big part of what our association does on behalf of all of our members. And so there you have it.
You said a little bit, when we were going through the various elements of the strategic plan, I think did you talk about recruitment? Getting the new,
there's a whole campaign right now.
Yeah, tell us a wee bit about that.
So we're attending various career fairs, and it's both IPIC staff as well as members of the profession in the local community. And ultimately it's about bringing attention to careers in IP generally. Because I think that, outside of certain very narrow avenues, I think most people aren't aware of what it is to be a trademark practitioner, a copyright practitioner, and a patent practitioner, and how to access it, and what that path is forward. And now I think we've actually managed to reach. I had a number. I think it's been something like just under 10,000 students that have come through at the various career fairs, which is very exciting. And it's not aimed at it's not aimed at lawyers. It's really aimed at the next generation.
And when you talk to a lot of our members and you say, well, how did you end up being a patent agent? Most of the time it's haphazard.
It's family or accident.
It's family or accident, right? And so we wanted to, make sure that there was a more proactive, measured approach to getting people interested in the career, knowing the career, understanding it, as Kat said, seeing the pathway, right? So that's the aim of our careers in IP. And it's been very successful so far. I mean, we've got great feedback, student engagement. People have even reached out, students have even reached out to me via LinkedIn as IPIC president to say, hey, I went on the IPIC website. So it's been a really successful.
So you have an advantage over us in that you've got a unified IP body.
Yes. Yeah.
So in the UK, there's CIPA, there's SITMA, there's the IP Federation, who's perhaps the industry perspective.
Right.
So we have an umbrella initiative. So we have IP Inclusive, organisation that was set up by the key stakeholders 7 or 8 years ago. And we have an initiative called Careers and Ideas. So it's doing the same thing, but we've had to do it in that kind of partnership, relationship way, because we don't have the benefit of single IP.
You're the voices of IP.
The voices of IP, yeah.
We were talking about the Own It campaign earlier, and I feel like that was the predecessor to the Career Outreach campaign. The Own It campaign was really focused on, or my sense of it was that it was really focused on small and medium-sized enterprises in the Canadian market, and the importance of investing in intangible assets and protecting intellectual property, not only in Canada, but abroad. And the goal there is really to foster that innovation economy in a way that serves the next generation. And now we're focused on
the next generation.
Exactly.
Yeah, exactly.
I was going to ask a question, actually. I think all these organisations face a challenge, which is making sure that you know that you are the voice of your constituents. And first of all, how many members have you got?
Close to 2,000.
Okay, so there's a lot of voices. How do you get them to understand that you're representative? How do you get a lot of buy-in, or do they kind of leave you guys to it? How does it work?
I think in that sense, and I'll give full kudos to Adam Kingsley for this. He's done a tremendous job in raising the profile of the association. We're seeing member satisfaction rates at an all-time high and member retention rates at an all-time high. I think, we had our meeting in Winnipeg last year, and there was a palpable energy, and people loved the meeting.
Yeah.
I think that there's a feeling that there is a lot of value add. How did we do it? I think it's the efforts of the staff at the association. They've been tremendous. It's a small team, but it's a mighty team. They've done a tremendous job, and with all the offerings and building trust in the kind of the IPIC brand, so to speak, and in the level of content that we put out, the communications that we keep our members up to date on a weekly basis of everything that's happened in the week before. So there's a lot of work that goes into becoming that voice, and I get the sense that our members feel it, and they're hearing it.
on something like right to repair, which is a complex issue, once it starts crossing over with IP, it really doesn't come up that much in the UK.
No, it doesn't. Does it? I was thinking
there's
that.
an interesting case law on it about when you're repairing as opposed to making as a patent case, but not that much on the policy level. I think because Britain's lost the ability to repair anything, possibly. A bit of a service economy these days.
Bin it.
Own it, bin it. So nuance point, and you can have different points of view. And I think we at CEPA have the same issue. We know that we're not going to be able to represent every point of view. There's going to be
divergence. Yeah.
But I think what we've probably got, and it sounds like what you've got, is the membership generally thinking they're going to come to a decent middle ground solution that's the right thing, and probably for the right reasons, as you said. Generally, for the consumer, I think right to repair, that's where that should sit.
Well, and we have to. I mean, as Kat will, and you can speak to this, is that we, unlike, other associations that are more divided, perhaps in your case in the UK, we represent everybody.
Yeah.
Pharma, generics. We represent, artists, content creators, and
users and rights holders,
and rights holders, and so
I think that, and we're very sensitized. So to use copyright as the example on the right to repair issue, it's very collaborative. When we strike a subcommittee in order to look at these issues, we ensure that we have representation from all sides. There's also deliberate. I was chair of the committee when we were going through that particular exercise, and there's a deliberate approach to make sure that nobody's thumb is on the scale too heavily. And the other piece that we aim to do is to ensure that both sides of the coin are expressed. So if you have people with divergent views, so for example, there's a statutory review of the Copyright Act, and often there can be very divergent views.
Right.
The approach will very deliberately be to express both sides of the coin. So, we don't have to stay silent on an issue.
Yeah.
And we can express, there's a faction of people that perceive this, faction of people that perceive that. And interestingly, one of the things I love most about the IP bar is I think that there is a true sense of not only professionalism, but collaboration and respect, mutual respect for each other. And it's remarkable how, despite having people in very entrenched positions, you can often build, maybe not full bridges, but you can often build, some form of a bridge between those. A rope, yes, a tightrope. A very, very
tight rope, exactly.
Yeah.
So I have a question for you. So, I mean, as IPIC...
Oh, hang on, this is our podcast. People don't do this to us.
I'm going to take over the mic a bit. So. No, but so as IPIC, we, Kat's mentioned that we represent copyright professionals and design professionals and patent professionals, trademark litigators, in-house, everybody. Who represents the copyright professionals in the UK?
So, CEPA's founding charter and principles are all forms of IP. So,
All forms of IP.
so our charter covers patents, trademarks, copyright, design.
Gotcha.
So our statutory, if you like, in the way that it is footprint, is all IP.
Gotcha.
The reality is, of course, that patent attorneys tend not to work that way. We do have those who specialise in copyright and design as well. That's their areas of interest. But by and large, patent attorneys. Yeah, that's
right. Yeah,
that's a reasonable assertion.
There's lots of patents to
Trademark attorneys are trademark attorneys, and we had the great schism in the 30s. So trademark attorneys used to be members of SEPA, but we had the great schism that resulted in the Institute of Trademark Attorneys, now Chartered Institute of Trademark Attorneys, coming into being. And that's our reality. So we've got that separation. IP Federation is the voice of industry, but only really big industry, and only really the biggest of those industrial bodies as well. So we have industry patent attorneys in membership. So we can legitimately say that we're talking on behalf of the patent attorneys, not necessarily on behalf of their employers. So we're very careful in the way that we talk about our role, our footprint, and what we're able to represent. So I was quite interested. I think, unless I misheard it, that you also talked about being able to be the voice of rights owners. Did I hear that, or did I mishear that?
Yes.
So again, in the UK, we would have rights owners groups, wouldn't we, around copyright, around design, around all of that. So
we did when we were working on kind of things like the CPTPP and other things. It was not just a patent thing; it was the whole IP profession needed to be involved and have a voice on this. So we've got lots of bodies in the UK on all kinds of things, including on copyright. And what we did there was, I think SEPA, because it has that extra bit of resource, was able to just provide the secretariat, if you like, for a slightly informal group of IP bodies, the barristers, the lawyers, but also copyright rights owners, design creators, all kinds of things like that. But it was a little more tricky to do.
Yeah, we're conscious that it's always a compact. There are always multi agencies. But we are the largest. We are probably, we have the greatest resource. So we occupy a privileged place in that kind of pantheon of IP type bodies.
And again, it's kind of one of the benefits of a good collective organisation is that we've got that resource which allows us just to help the smaller organisations. Yeah. All we basically was all sit down, have a conversation, agree what the common ground was, and then send it off to government.
Right.
Took a while, you can imagine. But it was still good. And I think it was that same thing you mentioned as well, that not everyone agreed on everything.
And you're not doing it any differently, are you? You're just doing that within the confines of one organisation.
Right.
So
and we divide out, the patent committee, the trademark committee, the copyright committee. So there is, groups of people, but it's all under the IPIC umbrella.
Yeah.
And so the submissions, flow up through our respective committees, but are submitted as IPIC.
Yeah.
Right. And then another quick question.
I'm loving it. Yeah.
Does the UK have a national IP strategy?
Oh, go on. Hobby horse.
No, it does not. It has an innovation strategy.
An innovation strategy, okay.
But the innovation strategy, we've been a little bit, if not critical, disappointed in, because it is actually slightly disjointed and has not really taken into account the amount of expertise, for example, that it has on the IP service side, which we recently calculated was £1 billion industry in the UK. So that alone, and the expertise and the kind of the world skills that we have, because we used to, like you guys, we get patents all around the world and trademarks and registered and so on. So we could do with a much better strategy, and IP wasn't big enough part of the innovation strategy, and it wasn't really thought through. It was a kind of an afterthought, I felt.
Yeah, and we have an issue in the UK. We have a revolving door of ministers, and nowhere has that been more true than in the world of IP.
Gotcha.
So when I first came to SEPA 2012, there was an IP minister who was on top of his brief. Got to know him. He was gone within weeks. And ever since then, it's been the same.
We had Boris Johnson's brother at one point. So.
Twice. We had him twice. Yeah. He was so involved in the revolving door, he spun out of it and came back in again. But that was because at that time, IP had been denied a standalone brief. So he was only the Minister for IP because it had been tagged on. So it became a part of his brief.
It's AI and IP now, isn't it?
It is AI and IP now, so at least we've got half a minister. And to be fair to the current minister, he takes his role really, really seriously. He's very into his brief.
So you have a minister of IP.
Yeah, well, so this one is AI and IP, but for 5 or 6 years we didn't. We had an IP tagged onto another ministerial portfolio, and it gets lost.
Oh, they were literally saying it's 10% of the portfolio. Yeah. But you're right; the recognition is a wonderful thing.
Yes, that's interesting.
Yeah, we're under Industry Canada, and heritage is sort of the way it tends to be regulated from it. But I love that idea. We have something new to advocate for.
Yes, now we want our own minister of IP.
We were so frustrated because the current minister for IP was the first one for a long time, and we were just getting ready to lobby for one. And it's like, well, if only we'd lobbied a little bit earlier, we could have claimed the credit.
Yeah. And also, you could have defined the remit more.
There is that.
I think
there is that.
IP and innovation are inextricable, and they're not the same thing.
Yes.
Obviously, I don't know.
No.
But I think personal views are it's innovation driven, and it's what does IP do to make the innovation work?
Right.
And I think having a minister for IP is brilliant. I'd actually kind of prefer a minister for innovation and IP.
Yes.
AI
So the
would be
AI
part
needs
of
to-
the innovation. Yeah. No, I think.
But-
well, now we've got some
Exactly.
new, fresh ideas.
So I'm conscious. I'm the timekeeper, Gwilym, and I'm conscious that kind of we're cracking.
It's because it's so good.
It's so good. I know it's so good. I don't want to bring us to an end, but I need to kind of nudge us gently there. So we'd said we're finished with hot topics. Have you got any kind of what's on
I've
the,
done mine. I've
what's-
done mine, which is Asian
Go on
privilege.
then,
I
Kat.
beat
Kat,
that
what's on the
drum.
radar
Yeah,
then?
so Kat-
What's on the radar?
I the small topic of AI when it
Yeah,
comes
the little
to all
tiny,
things.
tiny.
We have 3 hours to discuss this. I think the big one that we're likely to see just on a go forward generally is AI, both in terms of IP protection, AI in terms of practice, AI across the board, and I think it's going to keep us all busy.
You nervous about it? Or is the profession nervous about it? Not you personally. Is the profession nervous about it?
I personally am excited for it.
Yeah.
I think that it'll, but there are certainly elements of the profession that are nervous about it. I don't know that. Yeah, we'll see what the future holds.
Are you nervous about it, Gwilym?
I think no, I'm not. I think we should take it super seriously. A lot of people are saying it's rubbish, and it might be this year, but it won't be next year. It'll be really, really good in a couple of years' time. So I think it's inevitable. I think you've got to look at it, understand it, see where it's going to fit into your business, and then if it needs to be, change your business model going forwards because it is going to make a difference. So, yeah, excited is a good word. But it's hard work.
Apprehensively excited.
Change is hard work, isn't it?
Yes.
We're going to have to change all over again.
But they'll develop an AI to do that for us.
Yeah, change AI. That'll be all right. We take that. Yeah.
I think this is going to be a revolution. Like, I really don't think we have time to. I think we have to prepare. And I love that the UK has a minister of AI. Believe it or not, I think that's brilliant because I think this is going to be. We're going to look back, and this is going to be like the Industrial Revolution.
Yeah,
This is like
absolutely,
the digital revolution, and I think it's going to be in a short amount of time. And when you throw in quantum computing onto that, like the speed and the processing that's going to be, the capacity is going to be incredible. And I think in a decade, we're going to look back and see that the world changed quite significantly. I'm excited about it. Like Kat, I think we can't stop it. I mean, it's innovation. That's what what we're trying to promote. But I think we do have to look at it very carefully, and I think we have to keep our finger on that.
I look at my 2-year-old girl, and I look at her, and she's already talking to Alexa and telling it to do things for us. So we may be worrying about it. The next generation is to absolutely take it for granted.
They're going to own it.
Yeah.
They're going to own it. Yeah. Own it.
Alexa, play Twinkle Twinkle Little Star.
Again. So, INTA.
Yes.
That's where we are.
Are you guys frequent visitors? Is this always high on the agenda?
I'm on the board of directors.
On the board of
right
directors.
How
now,
many ribbons
so
you got?
yes.
How many ribbons?
just board of directors. Oh, look at you.
They're all stolen.
They're in the box outside.
Yeah, so no, very heavily involved with INTA for many years. I love this association. It's completely different than IPIC in the sense that it's a brand owners association. Mm-hmm. So its focus, and it's so wide reaching, it's global. And it's a fantastic organization because it has the clout to work with government, to liaise, to lobby, to work with the different IPOs. It's been a tremendous experience to be part of INTA for sure.
It's just awesome, isn't it? It's huge.
It's massive.
Oh, yeah.
Are you getting any rest, or have you got like 20 meetings a day?
Rest?
Exactly. I'm a patent attorney, so I kind of we've got 6 people here from the trademarks team, and I haven't seen them. They're just non-stop. You guys work so hard on this. It's really impressive, actually.
Thank you both for taking time out of that hard work to spend time with us on the podcast. We've really enjoyed it. We always end on a sort of like a tangential question. I didn't really know where to go with this one, but I think I've got somewhere to go.
No,
I think you're going to like this one. This is not too off the wall. Some of these questions can be a bit odd.
The last one. Do you know what the last one was? What's your favourite form of lateral? We really were scraping the barrel. We can do better than that. We can do better than that.
Now, if these podcasts go out of sequence, you've ruined the future questions.
Shall I give away the best answer was? Lateral thinking.
Oh.
How meta is that? It's not often we call back to that or forward, but anyway.
So let's
Because you could take that in many different
Yeah.
Yeah, and we did. So we took it in 4 different directions, to be fair. So it was quadrilateral.
Quadrilateral. He's all over this.
So just following the conference theme, and just so as I can end on a little bit of praise. So you'll probably guess where I'm going with my answer. Not necessarily your favourite conference,
Right.
but what's the favourite place you've gone to for a conference?
Bali.
Bali.
Yeah, it's ridiculous.
What did you go there for?
APA, the Asian Partners.
Okay.
So they go to slightly out of season holiday resorts. And I know my firm listens. I did get quite bad sunburn working by the pool. I didn't get the air quotes on the microphone. But it was a fantastic place. But I'm basically the wrong kind of skin type to sit by a pool in Bali.
I was going to say something, but I thought I'd be kind to you and not. So
There you go. That's my answer.
Kat, what about you?
I should say Toronto, Canada, just to promote my own city, but the true answer is Barcelona.
Oh, wow.
When INTA was in Barcelona, I thought that was fantastic as a host city.
It is a great city it's a great conference city, full stop. But it was a
Great
culturally-
city, yes, exactly.
Yeah.
It was fantastic.
Yeah.
I loved it. You?
For me, it would have to be Istanbul. I was there.
Oh, yeah, I can see that as well. Yeah.
It was magical, beautiful. The Turkish firms and profession really went out of their way to just host a fantastic conference. It was wonderful.
Did you get a boat reception?
We did on the
fab,
Bosphorus. It was beautiful at sunset. So it's just, it's too magical. It was fantastic. Yeah.
Don and Lee.
Whistler.
Ah!
Yeah.
Yay for Canada!
Yeah.
That's great.
I am in any case a great fan of.
That's an IPIC conference, by the way.
Yeah. I am in any case a great fan of IPIC's conferences. They're amazing. You should go to one. They are so.
Okay, I'm going to do a little
okay.
plug this year in Newfoundland,
Newfoundland.
St. John, Newfoundland.
Yes.
In September, it's going to be fantastic.
Yeah.
So if you like Whistler, you're going to have to come to St.
So
John.
unfortunately, when we went to Whistler, it was in the middle of climate is changing, isn't it? So there was no snow, was there?
No, there was no
there
snow.
was no snow. The resort was worrying about there not being snow. I think it was that. But so 2 abiding memories. One, bears. They're quite scary, aren't they? When you see them, when you see them walking past your restaurant.
Yeah, in the village, in the middle of the village. Yeah.
And is it pumas? Do you get pumas? Is it pumas? What's the things that drop out of trees at you? So
Apples.
I was
Scared of apples?
I asked. We stayed in one of these skiing lodge things. And I asked on reception where would be a good place to go for a bit of a run. And they said, you can run down to a lake. It's a little kind of hidden lake.
Yeah.
I did it. Did a lovely run. When I ran around there were all these signs saying, "Beware of
Pine
cougars."
cones,
Cougars.
Falling pumas.
What do you have in Canada that drop out of big cats? That drop out?
Cats!
Yeah.
No. I think it's like those little acorn type.
No.
I was thinking pine
It's an animal.
Pumas.
Yeah.
Pumas. Yeah, pumas.
Puma.
It is a cat.
Puma.
A big
Yeah,
cat.
it's a cat.
Fall
Not
out
this
trees
cat.
on you.
Yeah. So
Absolutely.
But I don't think we have pumas in Canada. It has
No,
to be,
I think that someone may have been trying to convince you the sky was falling.
No, but there
there were signs, and
No,
when
there are.
and then when I got back to the lodge, only last week one dropped down or took a dog.
Yeah, there are mountain lions and there's there
Bobcats?
are. It's some
No,
sort of
it's-
vicious. No, you're not wrong. You're not wrong. There are, and there actually have been some fatalities.
Okay, so
Because they stalk these cats, not cats, I mean, whatever they are, lions, mountain cats, or whatever. But they stalk from behind, so you don't even see it coming. It just jumps on your
Yeah,
back.
it's genuinely.
probably there's one in the tree, one behind you.
Yeah.
Yes.
Pincer action from the pumas.
Pumas.
Ah,
Yeah.
pumas,
It was
they
just
said-
my
they said puma.
pronunciation. I
I thought you were going to say that when you lick the wall. Do you remember you went licking walls?
that was in the salt mine in Poland. Yeah, that was. That was in Krakow. Yeah. Thank you both. It's been an
Thank
absolute pleasure having you on. Please share this with your colleagues in Canada when
Will do. Yeah.
Thank you very
when we
much.
publish. And Gwilym, I will see you. We've got one more to record today, mate. I will see you on the next one.
21 minutes.
Yeah. So I don't know whether you're listening to this podcast because you're at INTA and you're listening to it for the first time, or whether you're one of our seasoned listeners. But however you've come to the podcast, if you've liked it, if you've enjoyed it, then leave us a review on your platform of choice, because then we can extend our listenership.
That's exactly how the Beatles broke America.
Was it?
Oh yeah, just it was all about reviews.
Are you John and my Yoko?
Yes.
Perfect.